Welcome to the most recent installment of MacMull's Musings. Today is December the 21st, and this is going to be our last post for the year. Unfortunately, MacMull's Musings was on a brief absence in the last couple of weeks, but we're back to say season's greetings and so long farewell. We'll see you in the new year. Today I want to talk about an important case that was decided a couple of weeks ago in the Second Circuit, my home circuit here in the Northeast, involving Vans Inc., VF Outdoor LLC versus MSCHF Product Studio Inc., otherwise short form known as the Vans case. This is an interesting case, and we need to start with the product. This is Vans' somewhat famous Vans old school shoe. Anyone under the age of 50 will, I'm sure, immediately recognize this, and perhaps even those over the age of 50. And what happened was that there was a collective, so to speak, that put out a shoe that very much resembles the Vans shoe, and that's this shoe right here, otherwise known as MSCHF's Wavy Baby. And you can immediately see the parallels. It is essentially a black upper with the white distinctive line of the Vans shoe, essentially what they call microwaved or liquefied, as the sole is too. You'll see there's a dramatic wave in the sole. It's not a very practical shoe, from what I understand, but it nevertheless has all the hallmarks of a shoe. In any event, what happened was that there was the development of this wavy shoe. It sold in about an hour's time. It sold about 4,000 units for a couple $100 per pair. And given that, Vans immediately moved for an injunction that was decided in its favor, and then what I'm going to call MSCHF, appealed that decision to the Second Circuit. Now, interestingly enough, when this case was pending before the court, there was also the Supreme Court had not yet decided the Jack Daniels case, and I'm going to just quickly show you. I think we may have even talked about it, or I've written about it before. What the Jack Daniels case was about, because the Second Circuit's decision really falls in step with that decision, and I'm not so sure it's such great law. So the Jack Daniels decision, if you remember, involved the distinctive Jack Daniels bottle, and it involved a parody of the bottle that was essentially a dog chew toy. It was the same shape as the bottle, and it incorporated much of the same elements, but albeit in a sort of parodic fashion. The issue in Jack Daniels, though, I think was a little cleaner as far as I'm concerned, which was the court said, wait a second, when a product is going to essentially riff on another product and use its source identifying information as the basis of the riff, the Rogers test, which was a Supreme Court test, does not apply. Now, what was the Rogers test? Very simply, the Rogers test was that if a product or service had a parodic quality or was expressive, I guess the better example is if it was expressive in any way, the Rogers test applied. And the reason why the Rogers test is important is that it will allow in certain circumstances a plaintiff or a defendant, at least as a defense, to circumvent the likelihood of confusion analysis that in the Second Circuit are known as the Polaroid factors, in the Ninth Circuit they're known as the sleek craft factors. But the bottom line is this is multifactorial test to determine whether or not there's a likelihood of confusion. If, however, it's an expressive work and Rogers does apply, which was a test that was devised in the Second Circuit, you can kind of circumvent all of that and say, hey, wait a second, there's no likelihood of confusion because it's an expressive work. And that was the law that was laid down in the Second Circuit in 1989. In the Jack Daniels case, the court took another look at that and said, well, wait a second, that's not right. You can't. Expressive works, or at least application of the Rogers test, has its limitations, and this was a limitation because the court found that the indicator of source, namely the bottle of Jack Daniels, was being used in a trademark sense, even though this had parodic elements to it. In sum and substance, that's it. Now, the shoe case is interesting because it relies very much on the Supreme Court's recent decision in Jack Daniels. But the shoe case is interesting because, and here's where I think there needs to be some better refinement. Unlike the Jack Daniels case, in which you have that square distinctive bottle, here immediately in looking at the product, you see that there is it's distorted. And the importance of that distortion, I think, is key, because the Second Circuit acknowledged the existence of the distorted elements of the Van shoe. And to me, as I'm thinking about this, I find myself asking, do courts perhaps better reconcile these issues by asking themselves which comes first? Does the mark come first, or its trade dress, or does the message come first? In Jack Daniel's, at least arguably, the product came first. In other words, the product's distinctive design. Here, I'm not so entirely sure that in looking at that, without it being juxtaposed to the Vans shoe, that I'm necessarily thinking that this is the Vans shoe. Or even if it is, I'm inclined to think that it is somehow a riff on the Vans shoe, that there might be some sort of underlying message. And so will I ignore this phone call and continue? This, I think, is really important, because for me, the message comes first. And I'm inclined to say, if the message comes first, is it an expressive work? And if it is an expressive work, does Rogers apply? So today, we've dug a little deep. And certainly I invite your questions or comments when this is posted. But I think this is a really interesting case that is sort of blowing a hole through the standard Rogers analysis. And again, it can be argued that that was already established just a few months ago in the Jack Daniel's case, but this to me seems to be a little bit different. And the court, the Second Circuit, didn't give any deference to that distinction. In fact, it shot down once again the suggestion that this was expressive in nature, and therefore conventional trademark principles didn't apply. So happy New Year, happy holidays, and we look forward to continuing our segments in the new year. Thank you.